Trump? Oh my God. I can't believe that Donald Trump was right. And we're not Donald Trump supporters. That's right. California is stealing taxpayer money. Yeah, fraud and corruption. We're going to tell you how California is stealing taxpayer money.
If you want the full story, go to our YouTube.
They have a great plan. I'd like to tell you about the plan, and then I'll tell you who's involved in the plan. The plan is to cheat taxpayers out of their services, their money, IHSS, the food stamps, and everything else. As long as they can take advantage, that's all they want to do.
Who is specifically involved in the theft of money, services, and well-being in the state of California? That of which is a very easy question. It's the state, it's the county, it's the local municipality, and it's the courts. And it's anybody and everybody that's willing to aid and abet these people in the theft of your hard-earned taxpayer dollars.
Who do you report fraud and corruption to when the Los Angeles County, State of California, the Attorney Generals, and the judge are the perpetrators?
In order not to pay for services, the Department of Public Social Services, Jackie Contrara, teamed up with the California Department of Social Services, Jennifer Troyer, to deny Californians their benefits. If the recipient, let's say for IHSS, wants to file a petition for writ of mandamus in the Superior Court, let's say, for instance, the Los Angeles Superior Court, what happens is the County of Los Angeles hires an attorney. In our case, the attorney is Anita Susan Brenner. This attorney teams up with the Deputy Attorney General's office. That's right, no one other than Rob Bonta. From Rob Bonta's office comes attorney generals who will be representing the state against the person that filed the petition of mandamus. In our case, is Sarah Louise Dawley and Benjamin Deal. When we filed our cases in the Superior Court of Los Angeles, we were assigned 4 judges. The judges were James C. Chalfant, Melvin D. Sandvig, Curtis A. Ken, and Stephen I. Gorvich. In order to stop the person that's seeking benefits and redress through the court system, whether it's for IHSS or EBT, the county, in our case, it's the County of Los Angeles, teams up with the state of California and conspires with the judge at the Superior Court, in our case, it's the Superior Court of Los Angeles, to declare that person a vexatious litigant. The vexatious litigant statute can be found in the Civil Code of Procedures, section 391 to 398. You should have a similar statute in your state.
A vexatious litigant is a person who repeatedly files lawsuits without merit, primarily to harass or annoy the opposing party, rather than to seek a legitimate legal remedy. These lawsuits are often deemed frivolous and are intended to cause unnecessary delay and expense.
When a person is declared a vexatious litigant, a pre-filing order is issued, and that person can no longer file cases pro se, which means on their own, without permission of the court. Their name is placed on a vexatious litigant list for the public to see, and you can have an appeal, but it goes as new litigation and you have to get permission from the court. It may be granted or it may be denied. We filed 6 cases in the Superior Court of Los Angeles. We'll tell you briefly about each case in a second. The reason why the state, the county, and others are filing these motions to declare a person a vexatious litigant is because they want to stifle them. They have a meritorious case in many instances, and the person, the state agency, the county, they want to shut them down. They don't want them to talk about it because the state and the county don't want you to know this information because they would lose a lot of money. Case number 1 that was filed in the Superior Court of Los Angeles is under 24 STCP 02193. DPSS failed to provide adequate notice of the time to appeal a decision to the public. Notices of actions were mailed to individuals stating that you had 90 days to appeal when really you had 210 or 240 days to appeal. So therefore the notice would be considered void. Now just imagine if DPSS had to pay back all of the recipients for these notices. The second case is at the Superior Court of Los Angeles under the number 24 STCP 02906. And this case is about DPSS's failure to reimburse for EBT benefits. EBT benefits were issued during a declared COVID emergency. During the COVID emergency, the amount of EBT benefits replaced could be more than the 1 month allotment up to the amount of the loss. During the COVID disaster, regulation exceptions existed, and DPSS is supposed to investigate any theft or loss from your EBT account. Well, in our case, DPSS didn't investigate. And now they don't want to pay back the EBT. The third case is at the Superior Court of Los Angeles under the number 24 STCP 02392. DPSS waited 6 months after receiving my live-in self-certification form to approve my IHSS tax-exempt status. They're supposed to approve it or disapprove it within 30 days of receipt, but DPSS never states when they received it, nor do they let you know whether you're approved or not. So what that is saying is that you have to pay more taxes for that 6 months when you're supposed to be exempt. So who's benefit from that? Are you benefiting or is the state benefiting? The fourth case is listed under 24 STCP 03914 at the Superior Court of Los Angeles. This case is about protective supervision. There are exceptions to qualify for IHSS in certain cases of special needs, such as autism, post-traumatic stress disorder. The behaviors are not seen all the time, so the special need falls within an exception. DPSS and CDSS will not tell you this because they want to deny your services. They do not want you to qualify because then that's more money that they would have to give to the public for services. The fifth case, located at the Superior Court of Los Angeles, is under case number 24 STCP 03408. The case is about Exemption 2. Exemption 2 occurs when a provider has 2 clients and they have to work over the amount of hours to satisfy both clients, where you have to be approved for that. Well, in our case, 2 days before the Exemption 2 review was supposed to occur, DPSS closed my son's case without notice. And what this did was stop the exemption to review. But I'll get more into the exemption to review at a later time. The sixth case at the Superior Court of Los Angeles is filed on the case number 24 STCP 00069. This case is about veterans receiving IHSS benefits. DPSS and CDSS would tell veterans that they're not qualified to receive IHSS because the letters coming from their doctors came from Veteran Administration doctors, and Veteran Administration doctors are not considered doctors of California. Well, this is not true. Under the Veteran Administration, doctors can act in any state, regardless of where their license is from. So, CDSS and DPSS don't want veterans to know that they're eligible, even if they have a Veteran Administration doctor. This is what happened after filing our case in the Superior Court of Los Angeles. The lawyer asked, and her name is Anita Susan Brenner, she asked for a demurrer. This is to get your case dismissed. During the demurrer, she asked for a 30-day extension to file an answer, but it wasn't really to file an answer. She wanted to file a motion to declare us vexed litigants because we were filing a case in the court to receive benefits and redress for IHSS and EBT. Under a demurrer, you have to meet and confer. Well, Anita Susan Brenner, Sarah Louise Dorley, and Benjamin Deal did not meet and confer. But yet, they were given the decision. County and the state, once again through their attorney, Anita Susan Brenner, Sarah Louise Dorley, and Benjamin Deal of the Attorney General's Office, with Rob Bonta, stated that we filed 11 cases within the past year that was ruled adverse against us, which means we lost based on the merits. Not true. The Superior Court of Los Angeles, remember I told you who the judges were? James C. Chalfant, Curtis A. Ken, Melvin D. Sandvig, Stephen I. Gorvich. They all found that none of the cases were related, but yet they used the first case from the 24 STCP 02193, decided on January 30th, 2025 by James C. Chalfant. They used that case as a basis to decide their cases. Well, how can you use that case if it's not related? The evidence that was filed in each of our cases with the Superior Court of Los Angeles was not used in the determination of whether we were vexed litigants or not, nor was it used to determine the merits of our case. What happened to the evidence that was given in for our cases? Let's start with the 24 STCP 02193 case that James C. Chalfant decided. What happened to the evidence? Why wasn't it used to determine the merits of the case? You never mentioned it in your January 30th, 2025 order. A party is only supposed to receive one bite of the apple. Yet, the judges gave Anita Susan Brenner, Sarah Louise Dorley, and Benjamin Deal more than 13 bites of the apple. They were supposed to consolidate the cases and just get one chance to prove that we were vexed litigants. But repeatedly, over and over and over, these 4 judges allowed the county and the state to declare us vexed litigants 5 to 6 times. And that's each of us. Something is wrong with that. The person or the party is supposed to state which case was filed the earliest. In our case, it would have been Melvin D. Sandvik, who had the earlier case that was filed in the Superior Court of Los Angeles, not James C. Chalfant. So my question is, why did James C. Chalfant get to make the decision on whether we were vexed litigants or not?
Here's what other people had to say about the vexed litigant statute and the county attorneys.
In California, some big shots that I'm not afraid of. Now, about 3 years ago, I did a video. And I said in that video, when I realized that Richard Ian Ross, has so much power in California, where he can just call up a department in the city, the county, or the state government and get them to do anything against anyone that he wanted to. But people, you're slaves. They vandalized my property, they stole some of my property, and they stole my monies last night. Take this as a lesson. You working on behalf of Ralph Gonsalves, hire Anita Susan Brenner of the law firm of Torres and Brenner. She's a senior partner, a dunce woman, right? You hire them to come against me. This is how dunce Anita Susan Brenner is, of the law firm of Torres and Brenner. I go to their office. They have a law library. Her years of education and years of training. She brought a vexatious litigant against me using 2 matters that I filed in the district or the federal court. Right? The vexatious litigant law is clear. Not only is the law clear, but they have case laws such as Ralston versus Edwards.
We had to file our case in the Court of Appeals because we found that there was too much corruption in the Superior Court of Los Angeles. When we filed our case in the Court of Appeals, we got an administrative judge by the name of Elwood Liu. The order from the Court of Appeals that was given out on July 2nd and July 17th had so many errors. Take a look at the court order. In the order, there's one case missing. One case is stated twice. The 24 STCP 02193 case is stated 2 times. And the 24 STCP 02906 case is listed as from the Fresno County Superior Court. We never been to Fresno. All of the cases were filed in the Los Angeles Superior Court. Why were there so many mistakes on the Court of Appeals order? It wasn't bad enough that on July 2nd it had errors. Why 15 days later were the same errors printed on a different order? What's going on, Court of Appeals? If you look under the Court of Appeals cases that we filed, and I'll show the number of the case above, you'll find that Judge Elwood Liu sealed certain documents within that case. One is the petition of review. Next is the judicial notice, where there are certain exhibits and evidence included that they don't want you to see. Why were these documents sealed? Well, maybe because there's a lot of truth in these cases. Maybe they don't want you to know who the perpetrators are. Who's stealing the money from the taxpayers? Why were the cases sealed in the Court of Appeals? After the Court of Appeals, we had to take our case to the Supreme Court of California. We'll let you know what happens now.
So look, everybody, this is from Anita Susan Brenner. She is a manic depressive lawyer that is doing all of this for free. Look at all these paperwork she's mailing. I mean, look at just this one alone. Yeah, weighs about 3.3, almost 4 pounds. This is all coming from Anita Susan Brenner. She is an attorney that has nothing better to do with her life. She's out in Pasadena doing pro bono work for free for Dennis Weiland, who's making revenge porn and breaking into people's homes at night. And she was hired by Cynthia Roman Aronson, and their other goonies helping them do all this is Michael David Carbajal. So look, everybody, this is how sick these criminals are, and they are criminals because they're victimizing victims, women. And you know, sexual harassment via the internet, it's still sexual violence. And this is all coming from Anita Brenner, Anita Susan Brenner, the attorney.